Hi, Peter. How are you today?
Yeah, very well, Stan. And yourself?
Very well, thank you. And we're going to have another little chat today. And we're going to talk about, I suppose we're going to talk about partnerships. We're going to talk about uh, shareholder agreements. How about no shortcuts in shareholder agreements? Why, Peter?
Well, that's a good question, Stan. No shortcuts, because I'm doing a lot of consulting, a lot of valuation, and trying to sort out disputes between shareholders or owners of law firms that are specifically incorporated, which are the majority now, in my opinion, and avoiding disputes between shareholders and how you can make it a much smoother life cycle for your firm and avoid having this sort of fallout between shareholders because of an inappropriate shareholder agreement.
Okay, so do you want to talk about some of the shortcuts that firms take, or some of the pitfalls, or little things that
Yeah,
can go wrong?
so I'd like to start with some sort of broad context, but trying
Okay.
not to spend too much time on it.
Mhm.
And and that is that we've only had incorporated legal practices for 20 plus years. So traditionally, law firms have been partnerships for at least 150 years, maybe longer.
Right.
And, in that 100 plus year time frame, how law firms and partnerships, the relationship between partners um, has evolved and been fine-tuned, and practices have been accepted um, for the whole life cycle of a partner coming in and a partner going out. Now, all of a sudden, it's not been that long. 20 plus years is not that long. And what that 20 plus years means is that some of these law firms are now going through generational change. And that's when sometimes things get a bit sticky. And when they get too sticky, they need to come to me to help them sort out their differences. And so you've got a partner, law firms have worked well, learned from trial and error to work as partnerships. Then the shift has happened now towards incorporated legal practices. And but the shareholders agreement that defines the relationship between the owners has not evolved in a shareholders agreement as well as the relationship between partners as documented in a partnership agreement. So that's what I'm concerned about today, Stan.
So we actually need to reassess the agreements and try to come up with a a more forward-thinking, up-to-date way of dealing with equity in an incorporated legal firm.
Exactly. And so I think a reasonable place to approach this problem is to have some appreciation for how partnerships actually work, what are the pros and cons of partnerships, and how can we bring the pros and leave the cons behind into a different type of entity being an incorporated company, legal practice. And so what the people have been complaining about partnerships for a long time. And it's almost at the point now where people just automatically assume that if they're starting a law firm, it's going to be incorporated. And there's very good reasons for that. Could be tax, could be asset protection, could be all sorts of things, governance. But what happens is that if you're starting a law firm, you might go to your accountant and say, I need a shareholders agreement. And then the accountant will just off the shelf give you a template without thinking too much about it. And then you're in a hurry and you're excited to get your law firm started. And you're using maybe a shareholders agreement that was never designed for a law firm, let alone a professional services business. Maybe the last client that the accountant handed that template to was maybe a manufacturing business. maybe a retail business, who knows? But chances are it wasn't a law firm. So, in a broad sense, a lot of problems are now arising as a result of the need, or look, law firms will evolve naturally, and the shareholders agreement has to be able to cope with that evolution, just as a partnership agreement copes with the fact of partners, growing into the role from associates into partners and then retiring and then leaving. So all of that is taken care of in the partnership agreement. It's tried and tested. And now we need to have much more thoughtful arrangements with shareholders. And this is the hard part, because it's a relatively new, 20 years is not that old, a relatively new type of entity. The practices are not established as well as with partnerships.
So have you worked on these agreements yourself?
So
the new agreements?
Yes, what I do is, I'm not a lawyer, obviously, or maybe not obviously, but I'm not a lawyer. But I've seen where they all have friction, where they need to address issues which they're almost sometimes completely silent or inappropriate. And so what we will do is we will draft a heads of agreement type situation. These are the important aspects or elements that need to be addressed in a shareholders agreement. And it's hard. It's hard. Often people don't want to think about what happens when someone wants to leave, because you're excited about joining forces with someone and starting a new venture. The last thing you want to be thinking about is what happens if it doesn't work out or someone wants to leave.
Yeah.
And this is where partnerships have an advantage, because they realize that partners are coming in and partners are going out.
It's fluid.
They're fluid organizations. And you've heard me say before that one of the strengths of a partnership is its fluidity, its ability to survive and cope with partners coming in and going their own way. Now, partners leaving a partnership, it's often an emotional situation. Sometimes it's not done very nicely or considerately, and sometimes it's not done in favor of the timing of the partner who's leaving. Sometimes people are pushed out sooner than they want to be pushed out. So, but it doesn't create a type of scenario where the whole entity is at risk. The partnership carries on.
Whereas if with shareholders in a shareholder agreement, it is at risk. If suddenly a shareholder wants to go and there has to be an agreement on the value, et cetera, and to make it happen. And if it is acrimonious in any way, it can get very, very messy. And that's the point.
So,
right? So it's really critical. It's really critical that the agreement is set up correctly in the first place.
And obviously we can't go into detail in this conversation about everything that can go wrong, but I just want to maybe finish with where you can get it right. And that is when you're bringing an employed lawyer into ownership. At that point, you can create a shareholders agreement that not only takes care of that employed lawyer coming into ownership of the firm, but what happens when someone else comes in following that person, and then what happens when someone leaves ownership. That is an ideal opportunity to completely restructure your firm in the sense of working out what the firm will look like, how it will operate under the shareholders agreement.
Right. Thanks, Peter. That's great. And I suppose what we're trying to do, obviously, is encourage people to contact us and sort these things out before they become too messy. Right?
Exactly.
Okay. Thanks, Peter. Have a good afternoon.
Thank you. Bye-bye.